So the Supreme Court issued a 6-3 decision last week that drastically curtails the executive agency authority and will help to stop what the ATF is currently doing with their overreach with pistol braces and then also things like bump stocks. So let's talk about this. But real quick before we jump in this video, if you think the ATF needs to be reined in, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I will leave a link to them down below where you can check them out. As I mentioned in the intro, in this video, we're going to be talking about a major Supreme Court decision that was issued last week. The case we will be breaking down is called Biden v. Nebraska. This case was decided 6-3 against President Biden and his administration's attempt to interpret a federal law how they wanted to create a new law which would allow them to forgive billions of dollars worth of student loans, and that's what they were aiming for. Now, although this case deals with non-2A issues at its core, this case is about what powers an executive agency has and what powers they have to go beyond what the express text of a statute says they can do. In this case, it was about whether or not the Department of Education, at the behest of President Biden, could create a new program blatantly forgiving billions of dollars of student loans under the HEROES Act. The Supreme Court, in a 6-3 decision authored by Chief Justice Roberts, found that the agency could not do that. Now, you may be asking yourself, how does this play into the Second Amendment and the Second Amendment context? Well, as you may recall, we recently received and saw the West Virginia v. EPA case that was issued by the Supreme Court, and then also the Sackett v. EPA case that was also issued by the Supreme Court. And we now know that the Supreme Court is on a very active mission to stop rogue agencies and their broad interpretations of statutory language. The Supreme Court also recently granted review to the Loper v. Raimondo case, which deals entirely with the doctrine of Chevron deference and whether or not it's still valid or not. All of these decisions are now stacking up against the ATF as an agency and their current rules, which go beyond the express language of the NFA and GCA. This decision by the Supreme Court further signals that the ATF's pistol brace rule, their bump stock rule, and then their rule on frames and receivers is ultimately going to be doomed and will be struck down. So in this 6-3 decision, the Supreme Court started off by outlining the timetable of what the agency did and the ultimate flip-flopping of interpretations that the agency engaged in. Justice Roberts, in writing his opinion, stated that during the first year of the emergency, the department's Office of General Counsel had issued a memorandum concluding that the Secretary does not have statutory authority to provide blanket or mass cancellation, compromise, discharge, or forgiveness of student loan principal balances. However, after a change in presidential administrations and shortly before adoption of the challenge policy, the Office of General Counsel formally rescinded its earlier legal memorandum and issued a replacement interpretation, reaching the opposite conclusion. So in this case, the agency had an original interpretation that found that they could not directly forgive student loans under this statute and under the express language of that statute. Then suddenly they changed their minds, rescinded the previous memorandum, and issued a new interpretation and a new guidance that they could forgive those loans which they said they could not do before. If this flip-flopping of interpretation sounds very familiar to the 2A context, that's because it is very relevant to what the ATF has done on other issues like pistol braces and bump stocks. The very thing that the Supreme Court found at issue in this case is what the ATF is also doing. For example, there are multiple ATF guidance letters and memos which state very clearly that bump stocks do not meet the statutory definition of a machine gun under the NFA and GCA, and therefore they are not machine guns. But then suddenly they changed their minds, rescinded those prior letters, and now they claim that bump stocks are in fact machine guns under the text of the NFA and GCA. The ATF did the same thing with pistol braces recently, where for 10 years they had issued letters, they had issued memos that said that a braced pistol could never be considered to be an SBR, that attaching a brace does not magically make a gun into an SBR. However, suddenly they created a new rule saying that, yes, these items have always been SBRs, that they are going to classify them as SBRs, and then they rescinded their prior interpretations and said, we'll now follow our new interpretation. The Supreme Court in this 6-3 decision is stating that this type of agency flip-flopping is no longer permitted. Justice Roberts, in his opinion, stated that the Secretary's plan has modified the cited provisions only in the same sense that the French Revolution modified the status of the French nobility. It has abolished them and supplanted them with a new regime entirely. He then states that this type of change was not what Congress authorized, and therefore the administration in all reality is trying to create a new law on their own and trying to just do it all by themselves. Again, very similar to what the ATF is doing with pistol braces and bump stocks. Then Justice Roberts hits on the agency overreach just kind of generally, not just in the EPA context, not just in the Biden administration and the Department of Education context, but just agency overreach altogether and how the Supreme Court is going to address this. He states in this opinion that the question here is not whether something should be done. It is who has the authority to do it. Our recent decision in West Virginia v. EPA involved similar concerns over the exercise of administrative power. Under the government's reading of the HEROES Act, the Secretary would enjoy virtually unlimited power to rewrite the Education Act. He then goes on to say that the dissent is correct, that this case is about one branch of government arrogating to itself power belonging to another, but it is the executive seizing the power of the legislator. The Secretary's assertion of administrative authority has conveniently enabled him to enact a program that Congress has chosen not to enact itself. He then concludes his opinion by saying, all this leads us to conclude the basic and consequential trade-offs inherent in a mass debt cancellation program are ones that Congress would likely have intended for itself. In such circumstances, we have required the Secretary to point to clear congressional authorization to justify the challenged program. And as we have already shown, the HEROES Act provides no authorization for the Secretary's plan, even when examined using the ordinary tools of statutory interpretation, let alone clear congressional authorization for such a program. So you may be asking, what does this all mean for the two-way context? Why is this important for what the ATF is doing? Well, in this decision, the Supreme Court is stating that an agency cannot go beyond the authority that a statute expressly grants it. The court is saying that what is required is for Congress to speak clearly on a topic before an agency can ultimately unilaterally decide that they want to change a section of the law or just completely change something altogether. Also, it should be used against an agency if they have a prior interpretation that says that they could not engage in that type of conduct, and then later they change it, rescind it, and say, yes, they can. That type of flip-flopping should be used against the agency. This ruling by the Supreme Court just adds to more cases which prove that the ATF is engaging in unlawful conduct, that they're going beyond what the statute says they can do, and that their rule on pistol braces, that their rule on bump stocks and frames of receivers is 100% invalid. And this ruling by the Supreme Court and some of the prior rulings, like in the West Virginia case, in the Sackett case, and maybe the upcoming Loper case, show that the Supreme Court will no longer permit this. They are taking up cases to rein in executive agencies, and maybe they will do that soon for the ATF. Currently, there is the Cargill bump stock case that is pending before the Supreme Court. There's two other bump stock cases, and I would say that the Supreme Court is very much on a mission right now. They're actively trying to rein in agency overreach and also rein in other things like Chevron deference. So I think Cargill now, with these slew of administration cases, is looking very likely that the Supreme Court will grant review and maybe also attempt to rein in the ATF. So I know this is something that maybe slipped past your guys' radar because it dealt purely with student loans. And I know a lot of people were talking about just the student loans aspect of this, but this could have huge implications for the two-way context because it primarily dealt with agency overreach and what authorities, agencies, and executive branches have and what they can do. And again, it could play into the context of the ATF. So good news for the two-way context, but if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.